Harvard Law School. Probably the same thing with Walter Stanford. I'm the only person who could not get into Stanford. So I want to talk to you about the Non-Human Rights Project and also about what led to the Non-Human Rights Project, and then about what we're doing. And then I'd like to leave at least, if I can, 15 or 20 minutes for people to ask questions or have any sort of a discussion. So, I was a much younger lawyer than I am now. When I first read Peter Singer's book in 1980, at that time I was practicing. I was practicing in a general way, but I was focusing on criminal work and tort work. And then I read Peter's book, and almost overnight, I changed what I wanted to do, because I had actually come into law school out of the anti-war movement in Vietnam. There's been so many wars since, and I used to say the anti-war movement. I can specify which one I'm talking about. So I came in out of the Vietnam anti-war movement, and I was very interested in issues of social justice. That's why I wanted to be a lawyer. And when I read Peter's book, and I learned about I learned for the first time about factory farming and vivisection, and began to really understand how non-human animals are treated and what numbers, I decided that I wanted to spend my time doing that, because I could not think of any group that more desperately needed a lawyer than non-human animals. And so for the first year, I thought I was the only one in the world. I did not, and I was actually almost the only one in the world, but not quite. It turns out that there were small chapters of what was then called Attorneys for Animal Rights in San Francisco and in LA, and a year later, they decided they wanted to become a nationwide organization, and I learned about a meeting in New York City in 1982, I think, 1981, 1982, and that's when I learned that there were at least a handful of other lawyers in the United States who were interested in protecting non-human animals. And that's what I began to do. I began to protect non-human animals in my private practice, which I still have, and also we would brainstorm when we would usually meet in San Francisco and try to figure out, what is it we could do, how the law could work. And we came up with various sorts of ideas. By about 1985, when I became president, and I would remain that for the next 10 years, the Animal Legal Defense Fund, I began to realize that the real problem was the fact that non-human animals were legal things. And a legal thing is an entity that does not have the capacity for legal right, as opposed to a legal person who does have the capacity for one or more legal rights. So as an animal protection lawyer, an animal welfare lawyer, we couldn't litigate on behalf of non-human animals directly because of the fact that they were legal things. And that meant that, again, they did not have the capacity for any sort of legal right at all. The law saw them as only having instrumental value and not having any kind of intrinsic value, which is really the main difference between a legal thing and a legal person. And then we also had a hard time even litigating on their behalf, because we began to run into the problem of standing. How do you litigate on behalf of a third party? And when the third party is not even a legal person, it becomes harder and harder. And so about 1985, David Faber, who was another officer of the Animal Legal Defense Fund, who was a law professor, and I began to try to think of how we were going to deal with this problem. And we really viewed the problem as a standing problem. And it turns out within the next 15 years or so, I began to realize that it was not a standing problem. In fact, standing was not a problem whatsoever. But for a long time, I did think that. And so we began to look at chimpanzees and try to figure out how they might be able to get common law rights. Now, I hope I'll have time to talk about why we chose the common law and why we chose chimpanzees. And we began to think about it and research it, and we had a draft of an article by about 1990 or 1991, and that's when Peter Singer came back into my life again and asked us, and since then I've become friends with Peter. I've been friends with him for 20, 25 years, and he asked David and I to submit a chapter to a book that he and an Italian philosopher named Paolo Cavalieri were going to have published, called the Great Ape Project. And they were forming an organization called the Great Ape Project, and they also wanted to simultaneously, with the forming of the organization, then come out with a book called the Great Ape Project. So David and I were very happy that we were able to get our ideas out. Now, as I look back, it was an embarrassingly primitive argument, but you'll see that it really doesn't matter because no one's ever heard of it, because Peter kicked our article out of the Great Ape Project at the 11th hour because he was concerned that we were not being philosophically pure enough for the article. So we told Peter that the reason for that was that we were not philosophers. We didn't have any intention of being philosophically pure. We had the intention of coming up with jurisprudential arguments by which we could win. But philosophers and lawyers don't have the same objects. So he kicked our article out, which really ticked me off. So what I did is I went to a legal research tool. I think I used Lexis at the time, and I did kind of an all cases, all states legal search for the name Peter Singer, and nothing whatsoever came out. And so I put in Tom Reagan, who was also an animal rights philosopher. Nothing came out. Then I put in Aristotle, and 10, 11, 12 things came out. And they were not very complex ones. They were just kind of brief cites as to one of the many things that Aristotle had written. And that was an epiphanous moment for me, because I realized that the philosophy that I had been reading so much after I had encountered Peter's book in 1980 was almost irrelevant to what we were actually trying to do. That judges were not trained in philosophy. They didn't understand philosophy, they weren't educated in philosophy, and they didn't care about philosophy. So that was something that caused me to say, okay, I'm not going to read any more philosophy, and by George, I haven't now. In 22 years, I've not read any books by a philosopher. So what we wanted to do was to figure out how to create arguments, frame arguments in the way that judges would understand and comprehend and empathize with, sympathize with. And that meant talking in terms of how judges were educated, what sort of things they write about, what sort of arguments they hear every day, so that at least the manner in which we were arguing would not appear novel, even if sometimes the specific arguments we were making would appear novel. So I began to think about, well, what kind of arguments can we make? And I began to think about why humans have rights and what are rights. And I actually went to the Boston University library and began to look through it. And I went back to the Mesopotamians, and I started looking at Mesopotamian law. And then I moved into Greek law, Roman law, Hebrew law, civil law, common law throughout the centuries, as I began to try to figure out how we might be able to create these sorts of arguments. And by that time, David had kind of dropped away. He would later come back, as he is now, with his own sorts of things. But I think he was appointed to the acting dean of his law school, and he got to be very busy. So I used to read these things, and I got early on the idea that not many people were reading these things, because I remember getting a book on Mesopotamian law and kind of putting it back, but not putting it back all the way, leaving it out an inch. And 2 years later, I came back, and it was easy to find the only book that was sticking out, about an inch. So I realized that this is a specialty field. So in 1985, when David and I began to work, we realized where we began to realize the difficulties involved here. And at that time, in my mind, I began to think this is going to take a long time to get ready. Because in 1985, there weren't any SOLDIFs, there weren't any law reviews that have to do with non-human animals, there weren't any classes being taught, and there wasn't even what was called then and probably now an animal rights movement or an animal protection movement. That really did not exist. So I realized that there had to be kind of a background of people beginning to understand what it is we were doing, or what animal rights was about, or animal protection, what it was about. And then we had to be able to come up with the arguments in which we might have a reasonable chance of persuading judges that we should be able to win. Because the way I conceived it, really from the beginning, and I still do, is that there is this legal wall, and the legal wall separates, really, persons from things. And as far as natural persons go, in the year 2014, from the year 1985, on one side of the wall were all humans, but only humans. And of course, at one time, up until the time of the 13th Amendment, even in the United States, there were humans on the other side of the wall, on the legal things side of the wall. But by 2014, there are, on this side of the wall, there are all but only human beings. On the other side of the wall are the rest of the animals. And no one has ever been able to articulate, even if you're a religious leader, a philosopher, a jurisprudential writer, I've never seen anyone articulate a reason why simply being human was enough to put you on this side of the wall. And it always seemed to me there had to be some kind of a quality that would be associated with being human. That would be the reason why you would be here, while say chimpanzee would be here. And so it was easy for a judge at that time, and pretty easy now, to determine whether a plaintiff might be a legal person, if with a natural person, a living being, as opposed to say an artificial person like a corporation. If he or she is a human being, then he or she is a legal person, and he or she may then have the sort of right that they are advocating for. But if they're not a legal person, that they're not human beings, then they're automatically legal things who don't have the capacity for any legal rights at all. So it's easy for a judge to say, well, you're not a legal person, therefore you don't have any rights, period. So in 1985, at that time I thought it would take about 30 years before we'd be able to file any kind of a lawsuit in which we had any reasonable chance of beginning to punch a hole through that wall. Arguing that the place where the wall was constructed was an irrational and arbitrary place. And we don't know whether we're going to be able to persuade judges that it should be somewhere else, but it certainly shouldn't be there. And there should be at least some non-human animals who should be on the other side of that wall. So in 1985, I figured it was going to take about 30 years to be able to have the world change, the zeitgeist change, and the ideas that we needed to be formed. And it turned out that I was wrong. It only took 28 years. So we're ahead of the game when we filed suit in December of 2013. And so in 1990, the Vermont Law School asked if I would teach an animal rights law class, which I did, and I've taught there for 24 summers. And I teach what now, at first I called it animal rights law, and then I've been calling it animal rights jurisprudence for the last few years. And that led, I think, to a relatively small number, or at least following it, don't know if there's a cause and effect relationship, to having other law schools begin to offer, at least animal law courses. But I make it clear to my students, I'm not teaching animal law. I'm teaching animal rights jurisprudence. So if you're coming to me to understand animals in criminal law, animals in constitutional law, landlord-tenant problems in animals, you've come to the wrong place, because I don't teach the law regarding animals as it is today. I teach what's coming up in the future. So what I'm going to be teaching you has absolutely no practical value right now, except to move you forward to be able to really get into the fights that are coming. With the exception of standing, I do teach standing still, so because it still can be a problem with animal protection litigation. In fact, it almost always is. So I want people to understand standing, because as I showed in the standing cases, I say before I start, I say you are about to enter into a field that is completely unprincipled, and don't take it from me, but we're 6 hours from now, after we're done, you're going to come to me and you're going to agree that it's entirely unprincipled and subjective. So I want them to understand that, or else they're going to be very unhappy. And this is from a person who's probably has the world's record for being thrown out of courts on standing. I haven't done it recently, but I was at one point. It was fairly regular, and I even had cases. I remember once in front of the Supreme Judicial Court of Massachusetts, where I was arguing a case. No one had mentioned standing. And I'm sitting down, I'm saying, anyone have any questions on standing? Nobody had any questions on standing. So I open up the decision, and what do I lose on? Standing. So I tell my students, well, if you want to do that, make sure you do standing. It's a real serious problem. But the thing really began to, or the area I think began to really explode when, for some reason, Harvard Law School asked me to teach animal rights jurisprudence in 2000. And at that point, once Harvard Law School was allowing this kind of a class, it was hard for a lot of other law schools to say, this is too stupid to have a law school class for. So that really helped. Simultaneously, I was trying to set out an academic writings that would be part of the process that others were engaged in as well, of making the idea of animal rights some reasonable within the legal academy. So I began writing a series of law review articles, and actually one I wrote for the Vermont Law School probably would not be accepted anywhere today, because I think it was 150 pages long and had 800 footnotes in it. But see, it probably would not be. But within it, all the ideas that I have been using ever since are there. So 16 years on, the kernel of everything, and sometimes more than the kernel, is all there in that law review. So then I published a series of law review articles, and then about 1998, because I was mistaken about something, and that was that anyone reads law review articles. So I thought they did. I now understood they don't. Not my mother, she hasn't written them, I'm sure, but other lawyers don't, judges don't. So I thought this is really not the way to proceed. So I still write a few of them, but I don't really write them anymore. It's not part of my job. I don't get promoted for writing law review articles, so I'm trying to communicate important ideas, and I realized that was the wrong medium. So I wanted to write a trade book, and that was Rather Than the Cage was the first book I wrote, and that came out simultaneously with my beginning to speak at Harvard, simultaneously with Peter Singer getting an appointment at Princeton. So that in the year 2000 was a big deal. And the arc of law schools where animal law of some kind was being taught began to really get steep. And it's, I don't know how many there are now, probably 130, 140 law schools within the United States who have some form of animal law. I don't think a whole lot teach animal rights jurisprudence like I do, but at least there's some form of animal law that a lot of students, hundreds and hundreds of them, get exposed to each year. So I also then in 1996 formed an organization called the Center for the Expansion of Fundamental Rights, which then became ultimately the Non-Human Rights Project, which was essentially me from 1996 until 2007. as I began to do all these things. And in 2007, after I'd written like 3 books, I said, and I sent emails out to people saying, I'm done theorizing, I'm done. Now we have to see how this is all going to play out. Plus, I wasn't getting any younger, and I didn't. Indeed, I had been concerned about that for some time. I think on my 44th birthday, I actually woke up and I realized, 45th birthday, I'm not getting any younger. You know, I am mortal. And you start to realize that at some time in your life. And so within a couple months, I resigned as president of the Animal Legal Defense Fund. I resigned from my law firm that I had formed. And I said I really have to begin focusing on this. I didn't want to work anymore with the Animal Legal Defense Fund, though I still do. In kind of the broad way that they do. They do a great job. I was interested solely in trying to kind of break through that wall, changing the status of non-human animals from things to person, or at least beginning that process. So in 2007, I really began doing that. I come to places like this, or law schools where I would teach, and I would go to the folks that I thought were the best students and say, do you want to volunteer for what became the Non-Human Rights Project? We have a lot to do. This is what I'm trying to do. And people would come, and I would I'd handed out all sorts of assignments, because I understood, at least in my own mind, how this was going to go. And then eventually, over the next few years, we had 10, and then 20, and 30, and then 40 people, and it began to get really too much for me. And finally, I said, well, I began hiring staff. People began to give us some money every now and then, and we kind of became a hierarchical organization with working groups and heads of working groups as we went towards the goal of beginning that process, and of really devising a long-term strategic litigation campaign. And one of the most important working groups we had was the legal working group. And the job of the legal working group for a long time, and that group probably would work about 20,000 hours over the next 4 years. And the job was to figure out, where are we going to file suit? Where are we going to file suit? And so the good news is that in the United States, we have 51 jurisdictions. Bad news is in the United States we have 51 jurisdictions. So we began to go through a series of about 60 different legal issues, and we ran them through all 50 states. So we ended up having about 3,000 separate memos, arguments within memos, as we would get volunteers to research various issues, because we wanted to put the states into some kind of a hierarchy. The issues that we were interested in, the issues of how do they view liberty, how do they view equality, how do they view habeas corpus. And habeas corpus turned out to be very important for us. In Rattling the Cage, I actually talked about the Somerset case, I think maybe a half a page or 1 page. In the case of James Somerset, he was a slave who'd been kidnapped as an 8-year-old boy from West Africa, taken to Virginia, and ultimately by his owner to London. And there he escaped in 1771, and he was caught. He was put on a ship, the Anna Mary, tied to the deck, and was going to be sent to Jamaica, where he would then be sold in the slave markets, and he would then work harvesting sugarcane for the next 3 to 5 years until he died. It was the average lifespan for someone who did that. So I was interested in how someone, and probably, it was probably his godparents then sought a common law writ of habeas corpus from Lord Mansfield, who was probably the greatest judge ever to speak English. And Lord Mansfield gave it to him. He allowed the writ of habeas corpus and required the captain of the ship to bring the body of James Somerset in front of him and give a legally sufficient reason for imprisoning him. And it was really a cause célèbre throughout London over the next 7 months, which was extraordinary. And I didn't understand how extraordinary it was when I began. Then I began to run into statistics like like the average felony jury trial in England lasted for 12 minutes, including jury deliberations. And juries would hear 10, 20, 30 cases a day, and then they vote at the end, guilty, not guilty, guilty, whatever. And when I realized that, and realized that the Somerset habeas corpus argument had gone on and off for 7 months, and plus there were lawyers involved. I didn't understand that when I did research either. I would go to London, or I'd go into the Historical Society of New York, and I would find transcripts. I had to put on white linen gloves and get rid of anything that could mark anything, and go in and kind of look through 18th century diaries, 18th century transcripts. And I realized that there weren't any lawyers around in England. Or sometimes I would see, if I'm going through a transcript, I would realize that only one lawyer is talking, and there's not another lawyer. And I could never understand why, until throughout the process of my research, I realized that nobody had a lawyer. There weren't any lawyers. It was very rare for lawyers to practice. Certainly in the Court of King's Bench, there was a bar there, but it wasn't very large. And then I read the Somerset case involved 7 lawyers, some of the most distinguished lawyers in London at the time. And I realized that this was a really big deal. And so Lord Mansfield then, on June 22nd, 1772, had then said of James Somerset, he said that slavery was so odious that the common law would not support it. He ordered him discharged. And that made a big impression upon me at the time, but I didn't quite know what to do with it. And then I went to London, and I went into Westminster Abbey, and I was going through Poets' Corner, and I see behind like furniture, which I had to kind of go and kind of push myself through, there was a plaque there to Granville Sharp, who I only had a slight acquaintance with. And he's England's first abolitionist. And it talked about his role in the Somerset case. And I began to look more deeply into it and realized that this was a really big deal, and the common law writ of habeas corpus was a really big deal, which then led me to write a book called Though the Heavens May Fall, which is a telling of the Somerset case. And the thing I'm focusing in on is, why would Lord Mansfield say what he said? He was a conservative judge. He owned a slave. Of course, the slave was his great niece, and all the complexities of that. All of his friends owned slaves. He was one of the most important people in England. Why would he do that? Plus, he had tangled with Granville Sharp and other folks that Sharp had working with him over the last 6 years, and had gotten really irritated by the whole thing, and had just thrown out the last case the morning of the day that James Somerset's godparents came in and asked for writ of habeas corpus, common law writ of habeas corpus. And he gave it to them. And you have to understand, to me, how stunning that would be, because a writ of habeas corpus is something only that a person is entitled to. Now, they were claiming that James Somerset was a person. He was entitled to a writ of habeas corpus. Now, Lord Mansfield could have done what many southern courts did, which was say, I'm sorry, a slave is not a person, a slave is a thing. And the other folks would argue, no, we're saying he's not, he is a person, or he ought to be a person. They'd say, well, we're not going to listen to that because he's a thing, so he is essentially invisible to the civil law. They'd say, no, he's not, he's trying to show you he's not a thing. Saying, well, a thing can't show you're not a thing because you're a thing. And that may sound silly, but it's the reason we lost at the trial level on all 3 of our New York cases, and we fully expected that was going to happen. But he didn't do that. He said, I'm going to basically assume without deciding that James Somerset could be a person, and then I'm going to hear oral argument over the next 6 months as to whether he is a person, and then said ultimately that slavery was so odious that the common law would not support it. And he was a person. He was discharged. So I wrote that book both to tell the story of James Somerset, but it's also a metaphor for what we're going to do in the Non-Human Rights Project, and it was a blueprint for what we were going to do. So one of the most important things that the legal working group did was to go through all the states and try to understand the ins and outs of the common law writ of habeas corpus in all 50 states. And whether or not, for example, there was a common law writ of habeas corpus in some states, or how extensive was it? Who made the rules for it? The legislature put those students down at, I'm sorry, those states down at the bottom. So by November of 2012, we had narrowed the number of states down to, I think, 6. And then we had a science working group. We put those folks on the problem of identifying these 6 states every ape, every elephant, every cetacean. And the reason I've chosen those animals in 2000 and 2003 in my first 2 books, because they appear to be so extraordinarily cognitively complex. So I've written about them and how complex they are, how autonomous and self-determining they are. So we were still then using that in 2013. And so they did that, and then on Easter Sunday we had one of our meetings in Manhattan, and we decided that we were going to, we chose the state of New York, which happened to be the place in which we were sitting. That was going to be the first place in which we would file suit. We identified we looked at the list of animals, and we finally focused in on 2 chimpanzees who were at a roadside zoo in Catskill, New York, Merlin and Reva. And we then, we decided, that was the end of March of 2013, we decided we would file suit the first week of December. And we're hoping that we'd be able to meet that deadline because we have a lot of work to do. We had to translate kind of general legal argument into the law of New York. And then we had to identify the chimpanzee cognitive experts throughout the world whose work we really wanted to show demonstrated that the chimpanzees were autonomous and self-determining. Then we had to ask if they would be involved with us. And then we had to, then New York has a horrendous requirement for affidavits that are brought in from outside the state, which we didn't really know until we ran into the problem. And it was so Byzantine that using an international treaty turned out to be an easier path to go. But we had to bring in firms throughout the world, because it turned out we had scientists in Japan, in Germany, in Sweden, in Scotland, in England, and in the US who were all going to file affidavits that talked about this issue, especially of autonomy and self-determination. And the reason we chose that is that I think my books before had shown, and also certainly the common law of New York and other places as well, showed that the common law supremely values autonomy and self-determination. So before we can get to that, when we go into a court, we file a brief or a memo, there are 2 things that we really have to have the judges understand first, which is, one of them is that a person is not synonymous with being a human. Person and human are not synonymous, because a lot of people think they are. In fact, you're a lawyer, if you're not a lawyer, almost everybody does, and most lawyers do too, and therefore most judges do too. With the exception of since the Citizens United case has been dawning on a lot of people that a corporation is a legal person, at least for the purposes there of the 14th Amendment. But a lot of people still don't really understand that human and person are not synonymous. So we cited a case from the Court of Appeals of the State of New York dealing with 1972 case dealing with fetal personhood, in which the court held that a fetus was not a person within the meaning of the Constitution, but that it was all part of a discussion of what personhood was. And they cited all kinds of commentators about what personhood was, which turned out to be great, because then we started researching other courts that have cited those commentators, and we wanted to confine ourselves to common law countries, our sister common law countries. And so we were able to find, we found 2 pre-independence cases in India, where an Indian court had found that a mosque was a person. that a Hindu idol was a person. We found a 2000 decision of the Indian Supreme Court that it found that the holy book of the Sikh religion is a person. And then we were able to find a 2012 treaty between the indigenous peoples of New Zealand and the Crown in which it was agreed that a river was a person. So it's clear, and plus one of the beautiful things was the Supreme Court of India, in finding that Sikh holy books was a person, was citing many of the same secondary sources that the Court of Appeals of New York had. And they said straight out, hey, person is not synonymous with human. A non-human can be a deity, can be a person. Anything can. It's a policy decision of a jurisdiction as to whether an entity is important enough, for whatever reason, that the legal that the jurisdiction legally thinks that it ought to be a person for one reason or another. And so that's really the first hurdle that we have to get across. First, we have to try to get it out of the minds of the judges that this is a really stupid argument, because obviously they aren't human, and therefore they can't be a person. So we work really hard. In fact, I think that after we have the introduction, one of the first things we do is we have a heading that says, human is not synonymous with person. And we begin to make these sorts of arguments. So we also argue under the common law, and a lot of people really don't understand that, because one reason is that nobody seems to really understand the common law or study it even. We're kind of become the age of statutes, but there's a common law that's bubbling beneath the age of statutes, and so we chose, or I chose a long time ago, and the Non-Human Rights Project pushes forward on it. The common law is really the law that judges make in the process of deciding cases that they're not required to decide in a certain way because of the statute or constitution. So the reason that we chose the common law is that if you're asking a judge to interpret a statute or the Constitution or an international treaty, you're asking the judge to interpret what some other entity intended when it wrote that statute or Constitution or international treaty. And the problem is that it's usually pretty clear that they didn't intend to include a non-human animal when they used the word person, or even if they didn't use the word person. It was not meant to embrace them. But the common law is made by judges, therefore the common law can be changed by judges. We still have a fight. I was just in front of the appellate court 4 weeks ago. We still have the judges want to know why this is not an issue for the legislature. Why isn't this an issue for the legislature? Why isn't it an issue for the court? But we're certainly prepared to answer that with cases from the Court of Appeals of New York. There's one beautiful case saying that the courts of New York have not just the right, but the duty to change the common law when it's appropriate to do so. So then we pound home. You have the duty to do this. These chimpanzees are legal persons because they are autonomous. They are autonomous beings, and that's one of the second things that we really pound home to the courts is the supreme value of autonomy. Right now in the state of New York, but elsewhere as well. And we use the human cases where courts say, for example, a Jehovah's Witness does not want to have a blood transfusion, even though it will save her life. And so the courts generally, certainly in the state of New York, will then say that the patient's right to autonomy, to decide to die, outweighs the state's interest in her life. That's it. And we saw the other day, at least I did all over Facebook, the woman who moved to Oregon. She had terminal brain cancer, and she was using an Oregon right to die statute. How autonomous can you get? The legislature's decided that if you want to kill yourself, which New York hasn't, but if you want to kill yourself, go ahead. If basically, that's what it is. Autonomy is more important than the state's interest in the life of their citizens if the autonomous being decides that is so. I mean, there's certain circumstances where it won't hold, but there are paeans to autonomy, throughout the case law of New York and other places as well. Which is why we focused on having our experts bring in the scientific articles about why chimpanzees, about not why, but the fact that chimpanzees are autonomous. They can self-determine. And then, we were not expecting this. In June of 2013, the National Institutes of Health then says, basically, except for 50 chimpanzees, and I don't know how long that's going to last, but the rest of the chimpanzees are going to be retired to a sanctuary. It's really wrong to do biomedical research on chimpanzees. And they have a whole list of things that if you were being funded at all using NIH money, how you had to treat chimpanzees, and one of them actually uses the word self-determination. Your environment has to encourage their self-determination. When we say, well, it's not just our experts, it's NIH is also referring to the self-determination of chimpanzees. So it's really important for us to say, to have them understand, number one, that being human is not the same thing as being a person, and that autonomy indeed is a supreme value, and that chimpanzees are autonomous. Judge if you get where I'm going. So we then went back in September, a month after Easter of 2013, I flew to this roadside zoo in Catskill, New York, to check on Reba, or to actually introduce myself, to see Reba and Merlin, and it turned out that Reba had died 3 weeks before. And it was because there was only one kind of sad-looking chimpanzee sitting in this caged area. So I actually told him that I was coming back for him. Turned out I didn't, because in September, I sent my executive director back, and we learned that he had died the night before. So that really upset us for lots of reasons. We didn't have a plaintiff anymore, but also upset us about the fact that in 6 months, these two chimpanzees were both dead. And so we within the organization felt that on top of what else we were doing, we had a moral obligation to identify every chimpanzee in the state of New York and file a common law writ of habeas corpus on his or her behalf. So we did that. And it took us a month or two of trying to find them, and we eventually found what we believe were 6 chimpanzees in the state of New York. And 2 of them appeared to be in this little town of Gloversville, New York, and so I flew back there and went to see if I could confirm that they were not there. It turned out that one of them was not there. There was not a chimpanzee there. There was another roadside zoo that kind of had photos of the animals that they had, and they had a chimpanzee there. It turned out whoever was in charge of their website can't tell the difference between a monkey and a chimpanzee. So when we actually went there, we learned that there were no chimpanzees there. Then we found Tommy. And Tommy it turned out to be in a cage, in kind of a small room in a warehouse-like structure on a place that sells used trailers in Gloversville, New York. So I was able to see him and confirm indeed that he was there. Then we went on, we got in our car and drove a few hundred miles to Niagara Falls, where we thought that there was also 2 more chimpanzees there. And one of them was named Kiko, and one was named Charlie. In fact, you can see Charlie the karate chimp. You can go see the person who owns, we don't think you can own a chimpanzee, but the person who claims he owns Charlie, dressed him up in karate outfit and taught him various karate stuff, and you can see him being advertised as kind of a karate champion. And then I knocked on the door of this cement storefront where according to the website, there were 2 chimpanzees, I think 29 monkeys and 19 exotic birds, or something like that. And the guy came out, and while I never saw Kiko, or Charlie, I knew from the conversation that they were back there in the darkness. I couldn't see them, but I knew that they were there. And then we thought that there were 2 other chimpanzees who were being used for biomedical research at Stony Brook University on Long Island, and we never saw them. We haven't seen them yet because we're completely stonewalled by Stony Brook. The president's office wouldn't talk to us. The media people wouldn't talk to us. We'd call up the secretary. We'd call the scientists themselves. But we knew from looking at the scientific literature that these people were being funded and were churning out articles about the chimpanzees that were there at Stony Brook. So we talked to some other people who might have contacts that we didn't, and he came back and said, or she came back and said that there was a 95% chance that those chimpanzees were there. So based upon that, we decided to file a suit on behalf of Hercules and Leo. And so we then filed these common law writs of habeas corpus, along with our petition for common law writ of habeas corpus, along with 100 pages of affidavits, and then an 85-page memo. And we had assumed that we were going to hand this stuff in, and then we were going to get out something that says, denied, get out of here. And we would then have to take an appeal straight up on that. It turned out that we were pleasantly surprised. 2 of the 3 judges actually gave us hearings on it. And the judge who was involved in Tommy's case, and by the way, you can go to our website, nonhumanrights.org, we put up the transcripts of the arguments, we put up everything. The complaints, the briefs, everything that we do goes up. And I think even the transcript of the oral argument, which we made ourselves, is going up. And you can see what kind of argument we had, and the judge was very sympathetic to us. And he said our stuff was really great, but we're still going to lose. Because he's just not going to agree that a chimpanzee is a person. We said, fine, nice meeting you, very nice. And up we went. And then we went to Niagara Falls, and we ended up having a telephone hearing there. And that judge was very clear about what he was feeling. He said, if you look at the transcript at one point, he says, I'm not going to be the first to make this leap of faith. And we understood what he was talking about. So he said, fine, thank you, and we were going to take that up. Something then happened to him. We don't know. He seemed very sympathetic to us. And then in New York, you have to do something called settling the record in order to appeal. So the trial judge, which is for its own reasons, is the Supreme Court. The trial court is the Supreme Court of the state of New York. That judge, when we submitted a motion to have the judge settle the record, we waited a couple months and nothing happened. So we contacted the clerk and said, are you going to rule on our motion? And they said no. And we said, you mean you're going to deny it? No, we're never going to rule on it. So we said, okay, I've never litigated in the state of New York, so I thought, well, there's stranger things have happened in other places I have. But then we did our research and we said, he can't do that. He can deny it, let us appeal, but he can't just say, I'm not going to ever rule on it, because our appeal was stopped dead. So we filed a mandamus against him in the appellate court. And soon after that, he ruled in our favor, and he settled the record, and up it went. So then, and I'm arguing that case on December 2nd in Rochester. Tommy's case was last month in Albany. And then another strange thing happened when we then filed on behalf of Hercules and Leo's. It was close to that. We put our papers in and they came out saying, get out of here, you lose. So I wouldn't know what the judge looks like if he ran over me. I've never seen him. So, and then the appellate court for that area did something even odder, which is I filed a motion to be admitted pro hoc vice. And they didn't get something back saying, we deny your motion to be admitted pro hoc vice on the grounds that we're dismissing the case. So he said, okay, why are you doing this? And they explained why they're doing it. We realized the court, we didn't file a brief. It was just done sua sponte by the court itself. And we said, oh boy, these guys don't understand the writ of habeas corpus. So we filed a motion for rehearing, trying to explain to them what was going on, and they said, sorry, affirmed. So that case was just thrown out. And now we are refiling it in the next couple of weeks. Not on Long Island. We're going to bring it over into Manhattan in front of the court we think will actually follow the law, as the other two appellate courts did. And at least let us file a brief and argue it in front of them. So we argue, once we argue about the writ of habeas corpus, we really view the writ of habeas corpus. I mean, that's our cause of action. That's the key that kind of opens the courthouse door for us. We get the judge to understand that we possibly can win on a writ of habeas corpus. And the beauty of it is that it's a summary writ, so things are supposed to go fast. It's supposed to not be hampered by technicalities, even though apparently it was in one of the cases. And everyone agrees it's the great writ. It's the foundation of Western law. It's really, really, really important. And so once we can get the judge to accept, and what I urged, and we've had years of arguments about this within the Non-Human Rights Project, I actually ended up urging that the court do what Lord Mansfield did, which is to assume without deciding that our chimpanzees could be legal persons, and remand it back to the Supreme Court for the judge to issue the writ of habeas corpus. And then we argue, as happened before Lord Mansfield in the Somerset case, whether or not the chimpanzee is a legal person who's entitled to a writ of habeas corpus. Clearly, if he is a person, he is entitled to it. You don't take persons and shut them up in cages. So that's what I argued when we're talking about what was the remedy that I was seeking, which is we want you to assume without deciding, unless you want to decide in our favor, that'll be great too. But if you don't want to do that, then we want you to assume without deciding and then send it back down to the Supreme Court. So we're waiting to see what happens with our substantive arguments, which are based on liberty, and equality. Liberty is a straightforward argument that as an autonomous being, they have a liberty right to bodily integrity that's protected by the writ of habeas corpus. It's not as straightforward as I'm saying, but it's a powerful argument. And then we argue as a matter of equality as well, that to say that an autonomous, self-determining being can be locked up for his entire life. Why? Because he's a chimpanzee. We say that's a distinction without a difference. Who cares whether he's a chimpanzee? The question is he an autonomous, self-determining being whose ability to be autonomous and self-determining is then destroyed by locking him up and taking away his bodily liberty? And so we say, don't look at the chimpanzee, look at the autonomy and self-determining part. Because if you don't let him out through a writ of habeas corpus, you are condemning this self-determining autonomous being to spend the rest of his life locked up in a cage. And it turns out, Judge, that autonomy and self-determination, they are what writs of habeas corpus are meant to protect. So we will see what happens in these first cases. But we understand that it's we think we're a little bit more hopeful that we have a chance of winning even these early cases. At one point we didn't think we did. But in the third department, which in Albany, which is where I argued last month, in July, or in June, we learned that the owner of Tommy wanted to move him out of state into some place that we did not think was appropriate, because we had arranged for bona fide great chimpanzee sanctuaries to take any chimpanzees who we were able to get out to a writ of habeas corpus. We found out that we thought he was going to move him to some place that was not appropriate, I'll put it that way, for Tommy. Plus, we were concerned as a matter of law that removing the corpus, Tommy, from the state of New York might destroy our appeals, might destroy the subject matter jurisdiction of our appeal, because the court would be saying we don't have the corpus in our state anymore. So why should we issue a writ of habeas corpus? We can't serve it. We don't have any jurisdiction over this. So we asked the owner not to do that, and he said he was going to do that. Or at least he wouldn't promise not to. So we then sought a preliminary injunction in the third department, asking for an order ordering that he not remove Tommy from the state of New York. And we got it, which nobody was more surprised than we were. But we were very pleased because, as you law folks know, one of the things you have to show in a preliminary injunction is that you have a reasonable likelihood of success. So unless they're playing around, unless they're toying with us, we think that the judges who gave us the preliminary injunction, and it was unanimous, think that we had a reasonable likelihood of success. So Tommy's been in New York under a preliminary injunction, And so we reminded, in an oral argument, I reminded the court that we did have a preliminary injunction. But win or lose, the non-human rights is going forward because it is a long-term strategic litigation campaign. Some of the press are going to want kind of view it as you win, you lose, let's go on to the next story. That's not what we're doing. We understand that this is a long-term struggle. And if we win, it's not over. It reminds me of the I have to see if I can get this right. After the Battle of El Alamein in World War II, Winston Churchill made a speech saying basically we've won. We've won that battle. He said it's not the end, and it's not even the beginning of the end, but it is perhaps the end of the beginning. And that's how the Non-Human Rights Project views these first cases, and win or lose, we'll be expanding them to other states, and we'll be looking carefully as to why we lost and seeing whether we can fix the problem. Because if you look carefully at our arguments, I modestly say they are great. They really are great arguments. And so I think that a reasonable court, either now or at some time, should begin adopting them. And we'll see whether I'm a prophet or not. Thank you very much. I would very much like to hear any questions you have. Yeah.
Do you think there's any potential to use this approach for farm animals that are probably less autonomous?
It depends. Well, if they are autonomous things, then it's really good. It would be a really good approach. The last time I was looking at the literature on animals that are used for farm animals, I hadn't really seen it. It takes a lot of research, and no one does research, or very few people, on the cognitive abilities of farm animals. But I think what it does is really constitute kind of a punch through that legal wall I was talking about, where judges will begin, we hope, to move from just saying, well, this is a non-human animal, she is invisible to the civil law, to making a much more kind of nuanced, rational set of decisions. But even those of us within the Non-Human Rights Project who might feel that we really want to go after farm animals understand that my grandchildren are going to go after farm animals. I'm certainly not. And but our arguments are that right now, Judge, we're talking about chimpanzees, and beyond that, we're talking about autonomous, self-determining non-human animals. That's why we're here in front of you. Yeah.
How much do you think the success of your cases hinges on support from the legislative actions as well as a cultural shift, like the same way you find more Americans support gay marriage? How important is that among individual judges?
I think it's probably important. The New York judges are elected, so we are very, at least at the trial level. I think at the appellate level as well, where they're appointed and then they're voted on or ratified in some way. I don't know, but I think it is important. We also have a sociology working group. We have a number of working groups made up of sociologists who've been working on looking at academic literature as to what sort of links are there between judges' sociological characteristics and the way she might decide a case. And so, based on their tentative work, and of course one problem that way they have, no one in the Non-Human Rights Project agrees what an analogous case is to what we're doing. Is it a property case? Is it a civil liberties case? Is it a tort case? What's going on here? So one of the things that we think is possible, that the way in which a judge characterizes our case may determine the outcome. If she characterized that a property case, we might just lose. Civil liberties case, we might have a much better case. So based upon our sociological arguments, the judge who we went in front of first on Tommy's case, let me say a rural, conservative, white Republican judge did not fit our idea of the person who's going to be the most favorable to us. And he was extremely sympathetic to us, extremely sympathetic. And he just said, I mean, he's a Supreme Court judge, which, you know, he's a trial court judge. He didn't articulate it the way his brother did it in Niagara Falls. So basically, I'm not going to be the first to do this. You know, he's not a, you know, Tommy's not a person, and I'm, you know, but he said, I'll keep jurisdiction over this case. If you can tell me any other way of me getting Tommy out of there, come. We said, well, part of our argument is that there are no other ways of getting Tommy out of there. The fact is that no one's violating any animal welfare statute or reg. In fact, it's not a welfare case. In fact, that's one of the issues that we were prepared for at oral argument in front of the appellate court 4 weeks ago, with the judges saying the same thing. Why don't you invoke animal protection, animal welfare cases? And we're saying it's not a welfare case. It's a detention case. It's a habeas corpus detention case. When someone's being held against their will, nobody asks whether he's having a good time or not being detained. If it's against his will, the fact that treating him nicely is completely irrelevant. But you know, that's just kind of the problem that we have of trying to help judges kind of get their minds around what it is we're trying to do. Because they see animals and think welfare, protection, cruelty. We're saying that's not what we're talking about. We're talking about civil liberties, bodily liberty, habeas corpus, detention, imprisonment, get out of there. Yes?
Do you feel vulnerable at all to
Yes, yes.
The thing that really jumps out at me is just a ballot measure that would say, like, no non-human animal should ever be granted legal person in this state.
Absolutely.
The agricultural lobby could, you know, get that on the ballot
Sure.
in whatever state. And
Well, it really helps us look at the gay marriage cases. You know, when we win, and we will win. I don't know if we're going to win today, next year, 5 years, 10 years. I don't know when we're going to win, but we're going to win because our arguments are really good and they're rational and they make a lot of sense. And to not accept our arguments is arbitrary. That doesn't mean they won't be arbitrary, but I think that arbitrary arguments are not stable. Arbitrary decisions are not stable, and eventually they will fall. But once we win, I'm sure half the states will then pass such a referendum or pass such a statute, just like in gay marriage. As soon as Massachusetts, SJC allowed gay marriage, all of a sudden all these states said forget it. So a statute will get passed. But whatever caused that to happen, we'll have forever, and we'll be able to use that as ways of pushing forward. You know, that's why I say it's not a, oh great, you won, you lose, let's all go home. It's the beginning of a long-term, actually for me it's, you know, year 29, but for everybody else, it's the beginning of a long-term strategic litigation campaign, which is going to involve statutes. In fact, the judge wanted to know why we weren't trying to get the legislature to pass the statute. Well, one reason is, I guess we're 501c3. That's we can't do that. We're strictly of our status. But I don't think. But that wasn't not my response. And also, we're not competent in that area. But the real reason is that it is the duty of a common law judge to change the common law when circumstances require it. When the common law was passed with respect to all non-human animals, none of them were seen as being autonomous or self-determining beings or whatever, and now they are. And so the scientific facts that we have marshaled, and they are great, 100 pages of scientific facts, and that should cause the court to begin changing the common law so that, at least to the extent right now, that you can't keep this autonomous, self-determining being, you know, in a cage for his whole life. Yes.
So first, I just wanted to thank you for the work you're doing. I think it's really pioneering and ambitious stuff that I'm personally very excited by. As someone who's done a lot of writing as a legal academic and a lot of litigating as a practicing attorney, I can say that if there's one class of people that people ignore more than philosophers, it might be lawyers. And so I think the question I want to ask you is, I think the most exciting thing about your strategy to me is the expressive function of
Yes.
law and the potential law that you can
Yes.
create. Because we know that law in the books doesn't actually have much impact. I mean, looking back to HLA Hart, we have to look at the internal point of view, whether the law is actually being normalized and it's going to have an impact. And right now, people don't view animals as persons. They view them as things for us to use and abuse. So the question I have for you is, what component of your strategy involves changing our culture and implicating the expressive function of law. And two things in particular: how much is press a part of your strategy, and the second is how much is movement building, how much is kind of mobilizing communities and people out in the streets, out in their own communities to support the work that you're doing, so that it becomes even more effective, not just in the courtrooms, but on the dinner table.
Yeah, well, I think that's your job.
That's mine. We should talk about that.
Yes, I mean, we're, you know, as I say, we're just lawyers. You know, we're not community organizers or nationwide or international organizers. And we don't expect, you know, we don't expect judges to be way ahead of the rest of the population. You know, one of the reasons we had to wait so long is that I didn't think, at least, that the country was ready. I think the gay marriage cases have begun to show that things can happen. Attitudes can change, can be reflected in statutes and in cases. So we're operating within a culture, and it's up to everyone else to kind of lay the foundation so that we can come in and do the easy stuff, to just to have them recognize that the culture has changed, and that's one of the reasons why they should change the common law. And it has changed. You know, when I started doing animal protection work, I knew virtually every animal rights activist in the United States in 1980. I knew them all individually, like all 20 of them. I knew them all. And now, I probably know 10% of the ones who teach at the law school level. So it's a huge change, not just in the United States. The Non-Human Rights Project has been reaching out to work with lawyers groups in other countries too. We're trying to get them to begin the work of achieving the same sort of thing that we're trying to do in their countries, England, Switzerland, Argentina, Australia, Spain, Portugal, trying to get them to do that. Switzerland, in the way in which they do it. We say we can give you a lot of help, but we're not Swiss lawyers, we're not English lawyers. We have to work with you, and you have to lead us in saying, do you go to court? Do you go to legislatures? Do you get referendum? You know, how might you think that social change might be the best way of going in your jurisdiction? And then we can help frame the arguments for you. But again, you know, we're not coming in and saying we know how to do this. We have a fair idea how to do it in the United States, but we want to help others elsewhere. So we see it as a worldwide thing. But you know, we depend on your success. And it's the end, you do. Yeah.
My question is along the same lines, but again, thank you. I'm very inspired by this work. As a non-lawyer, what do you think non-lawyers can be doing to support the work of the Non-Human Rights Project? I know that's like a pretty open question, but
Well, if you're independently wealthy, come see me after the show. After the talk, you know. And other than that, you know, you have to figure out what you think is the best way of getting the culture receptive, having the culture become more receptive to the kind of arguments that we are making. As I said, that's a harder job than we have.
I have to end
That's
here
it?
because I got to see the room, but.
Oh, okay. Can we,
I mean, we could hang out after, maybe outside.
Okay.
Regarding,
One more question.
okay, regarding GAP, Grade A project.
The Grade A project, yes.
Okay, chimpanzees is one, but there are many other, I suppose, in that GAP. Just chimpanzees are the only.
All the Grade A, chimpanzees, bonobos, gorillas, and orangutans. Those are the four. And us, we're the 5 species.
Starting from chimpanzees,
Yes.
and then we move on to other species.
Well, we are already planning cases. We'll be filing another chimpanzee case, refiling it in New York, filing another chimpanzee series of cases in another state, and filing a suit on behalf of elephants in another state. So we're just kind of trying to take it, you know, slowly, step by step, kind of every time a judicial decision comes down, saying, okay, what does this mean? If we won, terrific, but still, what does it mean? If we lost, that's too bad, but still, what does it mean? And try to figure out, if we lose, for example, does that mean we need to change our cause of action? Do we need to find another jurisdiction? Do we need to find another animal? Do we need to have different sort of facts alleged? It's a very fluid thing, and this is the first time anyone's done it. So we really have little idea as to why our arguments would be accepted or rejected. Well, we know why they should be accepted, because they're really good arguments. But why might they be rejected? That's one thing we'll be looking very, very closely at, so that we can see what we can do to fiddle around with it and be able to file other suits that might have a better chance at success. Thanks again.
Thank you.